and that blows it up.
Non-stick dynamite today?
Not today.
Okay.
Nah, I want to get a call from the government.
Okay. Moving on to document 673, ETT's motion eliminate 16 to exclude references to prior outbreaks. And that is opposition, plaintiffs 56. We have real wires joinder, which was document 727, which is non-substantive, and reply document 957. So, in light of what the court just ruled, let's see what's left for this one. Counsel for ETT, go ahead, please.
Good afternoon, Judge. Tomasik for Terrible Herbst. Judge, along the same lines of the preceding motion, Terrible Herbst moves this court to exclude references to prior outbreaks. Any such reference and argument by counsel lacks foundation and is extremely prejudicial, especially in light of the Southern Nevada Health District's clear definition of outbreak, the clear testimony that they did not conclude that any cases preceding August of 2020 fell into their definition of the outbreak. And the reason why Terrible Herbst brings this motion in particular is I know that this is not the Gallagher case, but in the Gallagher case, plaintiffs used an example of the outbreak in a misleading fashion by saying that one of the experts, Dr. Goldsmith, was going to tell the jury that hydrazine was the general cause of acute liver failure outbreak as defined by the Southern Nevada Health District. But unless the jury has a clear understanding of that definition and of all the foundational information that sets the parameters of what the SNHD finds the outbreak to be, it would be prejudicial to allow plaintiffs to reference any cases outside of the outbreak as related.
And the court needs a point of clarification, please, because as you heard Mr. Kemp / Mr. Parker say briefly before, is seems to be two definitions of outbreak, right? The definition specifically set forth by the Southern Nevada Health District, and then the definition of outbreak for what plaintiffs are calling an outbreak. So are you asking to preclude plaintiffs from telling the jury that, in their view, they're going to quote, this is an outbreak as long as it's properly distinguished from what the Southern Nevada Health District's view of outbreak is as written in their report?
Well, certainly as it was done in the Gallagher case, I think
this is Hunwardsen. Remember, this
exactly.
court has to look at these neutrally as motions
yes.
as to what is allowable and not allowable under law. I fully appreciate you all did them. Certain people were participated in the trial of Gallagher, but I do not, and shall not prejudge what people may do in this case based on people's assertions of what may or may not have been done in other cases, which is why I'm asking you this point of clarification of what you're...
Understood, Your Honor. If someone is up here and saying outbreak as defined by Southern Nevada Health District, and then such supporting evidence is used to mislead the jury into thinking that one of the plaintiffs preceding August of 2020 falls under that outbreak, it should certainly be barred. Now, I understand the argument made by plaintiffs that outbreak can be used in different terms, but if it's used as they used it before, as defined by the Southern Nevada Health District, we certainly find that that's prejudicial and misleading because the parameters for that outbreak have been clearly defined. And one other point, I understand that plaintiffs' attempt to state that outbreak was misdefined. Well, actually, the CDC does define outbreak to encompass food spray. And so under that definition, they did not find that any of the cases preceding August 2020 fell into their definition of outbreak because there was an issue with the communicable disease issue in their motion.
Appreciate it. Real Water, you had a joinder. Did you wish to be heard?
No, thank you. Nothing to add.
Appreciate it. Thank you so much. That means we go to plaintiff response.
Your Honor, I'll be brief. I think the court understands at this point what the issue is. What I would add to what we've already discussed is that the Southern Nevada Health District's investigation started as of August 1. So it created a parameter for its investigation. There are, and the 30B6 for Southern Nevada Health District, testified during her deposition. She was aware of other claimed injuries related to the consumption of real water, but they weren't a part of their investigation. And that's it. For some reason, defendant is attempting to use that time period as some definitive time when only real water related injuries could have happened. We know that's not the case. And so I also thought this motion, given real water joinder in it, seems to go against the stipulation that's not before the court yet, but was filed today, that real water, in fact, consumed by Mr. Hunwardsen and the other plaintiffs caused their acute liver injuries. Your Honor, Southern Nevada Health District admits that there were other injuries that predated August 1st, 2020. They just didn't investigate them. And so for that reason, I don't believe you can exclude our definition of outbreaks for injuries that occurred prior to August 1st, 2020. And just to give some context to it, Your Honor, the August 1st, 2020 date was the date that Christopher Brian Wren, the father of baby Wren, became ill. And they used that as the onset date of symptomology. It's nothing more than that. Do you have any questions on this one, Your Honor? Because these motions are somewhat similar.
Do you want it on the motion or your statement that somehow you all actually did provide the court the stipulation, which is not in here?
Has it arrived yet? Was
It's
it
not
already?
arrived to the court. Has not been submitted to the court, folks. I'm in my inbox. I popped in as soon as you just said that statement, counsel.
Yeah, I thought it was already sent, Your Honor. We signed it all up, we got it all done, and I will say Ms. Rojas was correct. That one line was missing from one of the last stip we had written, printed settlement we had.
Can
Or
we
statement
please
we
get
had.
it to the court? It's wonderful to keep hearing these representations, but may I actually have it if you want it to be effective?
Okay. I'm looking at Mr. Pepperman just to see if it's been sent.
I just emailed my office to ask them to submit it immediately if they haven't already.
Well, I can show you all the current inbox.
We believe you, Your Honor.
It's not in there. The only thing is your OST, you just submitted it within the last 45 minutes, but not the one that you all been promising the court. Thank you. Please get it into us.
And Your Honor, just for purposes of the court's record, the deposition was attached to our opposition as Exhibit 1, which was a 30B6 testimony of Dr. Sang.
Okay,
All right.
thank you so much.
Thank you,
Any
Your
final word? Go ahead, counsel.
Thank you, Judge. Jan Tomasik for Terrible Herbst. Again, the testimony is unequivocal. The CDC did not have sufficient reason to conclude cases preceding August of 2020 were part of a outbreak. Clear as day. The plaintiffs don't, explain why allowing them to categorize any plaintiffs before that date as part of that outbreak, as defined by the CDC, why that should be allowed. Therefore, we submit.
Thank you. I think they say in their opposition, right, no party should be precluded from using innocuous language at trial. So here's what the court's ruling is going to be. With regards to ETT motion eliminating number 16 to exclude references to prior outbreaks, the court is going to, it's going to be granted in part and denied in part with the clarification. The granted in part is if the term outbreak is defined by the Southern Nevada Health District as being utilized, then the term with regards, yeah, that's not the one they were talking about, thanks. That's the other motion, that you heard you say. Let me go back to my ruling. Granted in part and denied in parts. With regards to the granted, to the extent if it's being referenced as the Southern Nevada Health District or the CDC use the term outbreak, then it needs to clearly articulate whose definition is being used. It's denied to the term, to the aspect of precluding plaintiffs from also saying that if they're using a term outbreak, as long as it's clearly explained how a plaintiff's version or a defense version, right, anybody besides view of outbreak, that it's their own characterization of the word versus having the imprimatur of having the CDC and or Southern Nevada Health District's terminology. I think that really meets he needs and is accurate in accordance with applicable law. So that's the court's ruling with regards to document 673. Does anybody have any questions, or can we move on?
We can move on, Your Honor.
Counsel?
Thank you so much.
Yes, Your Honor, we can go.
Okay. Now let's move on. Going to document 623, Real Waters Motion Eliminating Number 15 to preclude media articles. Opposition thereto by plaintiff 798. And Real Waters replied 911. I did not see any joinder by ETT. So go to Councilor Real Water.
Thank you, Your Honor. I'll be very, very brief on this one, actually. I think we're fairly close. I think there's still a dispute, perhaps that dispute's been withdrawn, but we provided the court in the original motion with examples of media articles that would not be admissible, NBC News, Las Vegas Sun, etc. The plaintiff seemed to be concerned as to whether or not a plaintiff as a hypothetical could say, how did you learn about, real water could have made you sick? Oh, I saw it in the media. That kind of statement in and of itself, as to their discovery, we had not objected to. But then the follow-up question is, well, is it this article right here, move to admit? That's where our objection is. So it's a fairly narrow issue. We tried to work it out in our meet and confer prior to filing this motion. Plaintiff wanted to see the motion. That's our position.
Okay, thank you. Counsel for plaintiffs, is there really much of a disagreement here?
No, Your Honor, there's nothing that I can think of that's going to be an issue. Our problem is that the motion is very broad. With respect to the individual articles identified, we have no objection to that. We don't plan to introduce those as evidence, but to say that every potential article out there is excluded in a motion in limine without knowing that there's even going to be a need to admit it, and if so, being allowed the opportunity to lay the foundation to do so, we think is just a overly broad ruling that wouldn't make things easier at the time of trial. It's just going to make things more complicated if this were to come up by saying, well, we had a motion in limine on this and other arguments, and whether or not the motion in limine applies. So that's the reason for the opposition.
Let me tell you where the court was leaning towards an inclination. I wanted to hear your side first before I kind of said that. And I'll give you a minute to respond to the before you get last words your motion. But the court's inclination is to grant the portions already agreed to by the parties, obviously by stipulation or agreement with the parties. With regards to other media articles, to the extent if somebody is wishing to introduce a media article, which will not be defined as, for example, the Southern Nevada Health District, other things that are reports that may have been included elsewhere, does not thereby make them precluded. If somebody wishes to introduce a media article, that it needs to be brought to the court's attention first outside the presence of the jury so the court can rule on it timely in that regard. That's where I'm inclined to go. Counsel, do you want to be heard on that? And then I'm going to give a final word, of course, to the movement.
I believe that's an excellent compromise, Your Honor. Thank you.
Real Water agrees.
ETT, since you did file a non-substantive joinder, do you want to, and since the court was coming up with an inclination, was a little different, do you have a viewpoint you want to throw in?
No, Your Honor.
Oh, sorry. I want to phrase that not in the best way, so let me phrase it differently. Would you concur with the court's inclination, or do you have something you wish to address before the court makes a ruling?
I would concur with the court's inclination.
Okay, so the court's inclination turned into a ruling. It is so ordered. Thank you so very much. Okay, moving on to document 677. ETT's motion in A23 to exclude evidence or reference to hydrazine being in real water retail bottles sold by Terrible Herbst. Now this one, do realize that the court is going to ask questions in light of this hypothetical stipulation, you know, I have to say it, but at some point I'm going to get, does that modify what is the relief being sought or not? I'm not taking a position whether it does or does not. I'm appreciative that when pleadings were filed versus what's happened in the last 24-ish hours, a little bit more, so just explain the landscape of what you're actually asking in light of where things are, and then we'll Thank you.
I'll try my
Thank you
best.
so much.
Jan Tomasik for Terrible Herbst. Judge, I think we should address this motion as it stood. We filed it preceding any knowledge of the stipulation. The other aspect of that is the stipulation has not been filed yet. So I don't believe that we can address this, with the assumption that it has been filed yet. On that front, Terrible Herbst moves this court to exclude evidence or reference of hydrazine being found in real water retail bottles sold by Terrible Herbst. The fact of the matter is there's been no testing done, and yesterday we outlined that there are more differences between the Eurofins testing of the retail bottles than there are similarities. The Eurofins testing was of product sold by Whole Foods. It was distributed by United Natural Foods West, and that product was manufactured long after Hunwardsen quit drinking.
Stop it for a quick second. Isn't the Europeans testing a separate motion before the court?
It is, but it's the same foundation if the court allows me to just set the...
Okay, if it ties into this one, but remember, I'm ruling on these right motion by motion. Go ahead, please.
Thank you, Judge. Again, the Eurofins testing, it regards product that is more different from products sold by Terrible Herbst than it is similar. We outlined that yesterday, so I won't go through it again. But on that front, the plaintiffs should be precluded from referencing or suggesting that hydrazine was found in any product of retail water. That's exactly what the plaintiffs tried to do here with the Eurofins test. But it lacks relevance and it's extremely prejudicial. Going further, all of the expert opinions are mere assumptions on this front. Dr. Hudson was deposed, and the best he could do was offer mere speculation and assumptions as to whether the retail bottles sold by Terrible Herbst contained any hydrazine. Now, permitting such opinions to go before the jury based on assumption rather than a reasonable degree of medical probability is extremely prejudicial, more so than it is probative. It's essentially a guess, and therefore we'll submit on that front.
Don't ask a follow-up question because you know it's going to come before me. So I'm trying to walk through how this would be explained to the jury, right? Even though I don't have a stipulation, right? And so obviously it's nothing that you all know. I'm right now speaking with you also. I'm listening.
Can you check your email, Your Honor?
Not in the middle of me asking a question.
Oh, I don't see it.
No.
It may have popped up on your email.
Can't be filed, there is no notice of entry of order, there is no effective order. So whichever way you go, where I'm really trying to go with this is, my next part of my sentence was going to be, we have a representation from Council of Real Water, right? And I'm careful how to paraphrase it, but something about there inadvertently was hydrazine in the water for each of these plaintiffs that they direct. I'm close.
Unintentionally, there was a word change. That was the delay, sorry, Your Honor.
Oh, there was a word change since, okay.
But the one that's been submitted is now accepted by all.
Okay, so what is the language?
Unintentionally.
Unintentionally, okay, so with that. So if the jury, and I appreciate there's another motion pending, right? But at some point during the case, Real Water is going to need to say something why they're not contesting liability and causation of the carve-out if that extra sentence came in on whatever, not yet seen, but okay, so I'm just going straight to the liability rather than causation aspect. And if they're gonna say that there was essence, right, hydrazine in the water, and then, I appreciate it, thank you. So, then is Terrible Herbst asking this court to say, jury disregard that? I mean, I understand you're making contention that there may not have, Eurofins, you're saying the testing date, it was Natural Foods, a different distributor, different retailer, okay, all of that. But in your motion, you're asking to exclude any evidence or reference to hydrogen in the water. Isn't that plaintiff's case? I was gonna try and say it more eloquently, I'll just get to
Sure,
But isn't
sure.
that their cases, so they can't even say that? How can they even say that they have a case against your client?
Well, there's no evidence presented, and there's no expert opinion that rises to the degree of reasonable medical or a scientific probability on that front. So
Is it not evidence in the court? And you want to stop you for a second, because you said there was no evidence, right? If there's a stipulation by the manufacturer, right, that says there is unintentionally, previously, inadvertently, whichever, okay? Some amount of concentrate, amount to be potentially disputed in it, right? And it's saying hydrazine, then how does one get around that if that's not stipulated evidence for purposes of this case? And I'm not in any way taking away your supplemental briefing, this coming to me from a legally being bound standpoint. I'm focusing on your motion limiting here, because you're focusing on the evidence, not the legal intention of it, right? Here you're asking to preclude something coming in from evidence, but I'm kind of having a challenge of how that can be reconciled in front of the same jury.
And to be frank, it's challenging from our standpoint when we filed these, and we were just given a stipulation or notice of it yesterday, which has not been filed, okay? And on the same front, plaintiffs have admitted how that's possible. First of all, the concentrate is not what contains the hydrazine. There's an electrolysis process that it has to go through, and that's a byproduct of it. And furthermore,
But is that, I'm hearing what you're saying, and I'm sure Mr. Kemp will correct me if I say something incorrect, but if the concentrate's all the same, I feel like I'm gonna use the term electrification process, for lack of a better term, right, is the same. So the mixture, okay, the actual mixture gets added, right, it's the negative water goes to the distributor, is the same. So unless you're saying that the distributor somehow was able to do hydrazine, which hasn't been brought to this court by anybody, then isn't what is stated currently through the agreement of real water that some amount of hydrazine was, or, I mean, the court's already ruled on the ozonation issue, right? Which doesn't really impact you all anyway, because that's 2020, right? When it went to Henderson in year 2019, because you're only Hunwardsen, so we're not there. You understand the court's challenge on why I'm asking this
I
question?
do,
to see how
and not all concentrate is the same, and not all retail bottles contain hydrazine. Those are the expert opinions of plaintiffs, okay? So if we talk about the stipulation, there still exists the potential that it was manufactured with hydrazine, but it degraded and was not a substantial factor in causing Hunwardsen's injuries.
Okay, I appreciate it. Thank you so very much. On this one, I do not have any joiners, so that means I go to plaintiff for your opposition. Go ahead, counsel.
Your Honor, I was shaking my head and listening to defense counsel struggle to answer the court's question. Once and for all, I thought Mr. Kemp, and I told him this at lunch, he did a masterful job of explaining the process. The concentrate is the concentrate. There's not a single shred of evidence saying that there's a different concentrate for bottles versus jugs, or from 2018 to 2020. The concentrate, once and for all, is all the same. And there is no differentiation between locations, be it Mesa, Desert Inn, Henderson, or within a facility between one line to the next. There is just one and only one concentrate, Your Honor. And, which I also thought was strange, Mr. Kemp described the process, which will be further described by our expert, Dr. Naja. Your Honor, the electrolysis process, which results in the creation of a hydrazine byproduct, is in every bottle, every jug for the plaintiffs in this case. And what defense counsel seemed to either unwittingly jump over or simply didn't have an understanding of this. The stipulation also says causation. So there is no way of reconciling their position when you consider the strict product liability determinations or pronouncements made by the Nevada Supreme Court. There's just no way of doing it. A distributor, a seller is strictly liable, not unlike the manufacturer of a defective product. That's it. And so I understand why the court is hanging the motion for summary judgment, plaintiff's first motion for summary judgment in the balance, because you don't have the stipulation. And for that, I truly apologize. We have submitted it. I don't know why it hadn't shown up yet in the courts, before the court at this point.
Whether it's come in the last 12 minutes,
Right.
yes.
That's right. That's what I'm talking about. Not yesterday, or before yesterday, or when these motions were drafted. I
I see
agree,
you
Joe.
said motions, but I'm just.
We're past that.
Okay, so feel free to finish up your response, and then we're gonna get last word. Go ahead.
So, Your Honor, I also find it somewhat comical that despite how many times we've put before this court in the form of motions, Dr. Hudson's qualifications, he's a director of gastroenterology and hepatology. He is not our expert when it comes to how hydrazine was created. That's Dr. Najim. And so I don't understand why, I guess I understand why. It's a charade. That's the reason behind it, and they do it by parading these snippets from excerpts of Dr. Hudson's testimony regarding hydrazine. His opinion, Shane, can you put up Dr. Hudson's opinion, please? I think it's Exhibit D. It's one of the motions, Your Honor. And if I could approach again the screen.
Sure, as long as you're near enough to a microphone that court recorder can hear you, that's fine.
Thank you. And I believe it's on page 7, Shane, if you could. Oh, wait. This is Dr. Hudson's opinions as to all of the plaintiffs, but Myles Hunwardsen, the one that ET&T, of course, is most concerned about. This is what he says. And, Your Honor, I can read it to you, but you can see it on the screen. And he says, the last sentence says, Mr. Hunwardsen's consumption of real water from 5-gallon bottles and retail bottles were both substantial factors in causing his acute liver failure and subsequent need for liver transplant. Your Honor, the process in terms of the creation of hydrazine will be discussed at length with Dr. Najim. Hydrazine is a known liver toxin. The pathology in this case shows, even the defense experts agree with this. The pathology in the slides, I think it's Dr. Gong on the defendant's side of it, indicates that they can't rule out that it was a toxin, hydrazine, that caused the damage to the liver, which was taken from the pathology slides from Mr. Hunwardsen's removed liver. Our expert says it's consistent with hydrazine damage done to the liver. Your Honor, there is no mistaking here. Mr. Hunwardsen's liver was removed because of significant acute liver failure. The pathology reports of that liver demonstrates a toxin. Our expert says it's hydrazine. Hydrazine was in all of the water, in this case, consumed by these plaintiffs, not only by stipulation, but by evidence. And there's no doctor on the defense side that can say otherwise. Unless the court has any questions.
I do not, thank you.
Thank you so much, Your Honor.
Counsel, you get last word. Go ahead, your motion, please.
Judge, if I can direct your attention to page 17 of plaintiff's opposition, line 19. They themselves state, quote, "The only way that a retail bottle would have had no hydrazine whatsoever in it is if the hydrazine in the bottle degraded over multiple years." That's exactly what could have happened here, Judge. There is circumstantial evidence.
Who is going to testify to that? That there
Their
was a-
own expert, Dr. Najim.
Right, you're saying Dr. Najim is going to testify that the
To degrade.
hydrazine did degrade over years, and plaintiff is paying this expert to testify in this case?
There is a expert, Dr. Najim, who testifies to hydrazine degradation in retail bottles.
No, I'm hearing what you're saying, but I don't recall reading in his report in the reference section that Mr. Parker, right, just referred to. Doesn't seem consistent that he's going to then testify that there was a degradation, and I'm gonna mispronounce, right, I'll just phrase it a little bit differently. Having a challenge today with the word, sorry. That somehow the hydrazine degraded in the Terrible Herbst. Is that what you're saying he's going to say?
In general principles, part of his testimony is that hydrazine degrades over time. And consistent with all of the evidence in this case, that's why you have millions of retail products that did not cause any injuries because there was no hydrazine.
But counsel, I'm hearing what you're saying, but in reading your motion, how would that testimony even come in if you're saying that he's gonna say it? Because you're asking to exclude any evidence or reference to hydrazine in Terrible Herbst. So I'm having a challenge of how that information, even if you were viewing it as helpful to your client, can even come in by your motion eliminate.
Your Honor, in light of the recent stipulation then, I'd ask for maybe a supplemental briefing on this motion to reconsider the motion in light of the stipulation.
Supplemental briefing on what, counsel?
On this motion.
Right, I'm trying to get an understanding of what you're saying the supplemental briefing would cover. Remember the supplemental briefing on the motion eliminate number 1, right? We had to put the lens of what that was, right? That was yesterday's very first motion, and there wasn't anything in stipulation. There wasn't even a review by your firm yet of the proposed stipulation to know its exact language, right? So once of caution, and there was an issue raised by your co-counsel colleague, however you like to phrase it, right? That there was an issue whether they were bound by the stipulation. So the supplemental briefing, right, is on the legal issue about being bound by the stipulation. Yours is a evidentiary motion to eliminate, right? The other was a summary judgment. This is a motion to eliminate. And this is a motion to eliminate to exclude evidence. So I'm hearing what you're saying, but I'm not really seeing how a supplemental brief would be of assistance.
Judge, it goes back to an earlier question about how you approach the evidence in this case in light of the stipulation. So on that front, I would request time to add supplemental briefing to this motion in light of that.
Okay, I'm hearing your request. Let me hear everybody else's viewpoint on that, okay? Did you have a chance to finish up your argument?
Yes, Judge.
Okay. Counselor Plaintiff, you're saying, so I'll ask you next, and then I'll see if Real Water has a position. Go ahead, please.
Sure, Your Honor. And I'll be brief.
Just on the supplemental briefing.
Exactly. I'm going to be brief on the supplemental briefing.
Thank you.
When ETT's counsel came up, after the court spoke for a few seconds, he said that he wants this motion decided as we stand today. And then after argument, he asked for supplemental briefing. If he wanted or felt that supplemental briefing was necessary at the beginning of his argument, that would have been one thing. But he made a decision when he started arguing that he wanted it decided as is, and we argued it as is. The only question the court asked, which again he said that he wanted it decided as is, was whether or not there was any way of reconciling the stipulation, which we've heard on the record, versus their position. And so I addressed that, he addressed it, and I think after my argument, and he began his rebuttal statements, the court asked a couple more probing questions, that made it, I think, clear to defense counsel that he could not have it both ways. He wants to argue a certain position with hydrazine, but then does not want the retort being discussed with the expert on hydrazine, which you cannot do. You can't mention it in one breath and then use it as a shield in the second breath, Your Honor. And so I don't believe supplemental briefing is necessary. I think the court's questions have actually provided the answer to where we are on this motion, Your Honor.
Real Water, do you have a position on supplemental?
No position, Your Honor. Thank you.
Counsel, I'm listening to what you said. I don't see how supplemental briefing on this motion limine would be, well, you oftentimes do supplemental briefing, right? Because you're saying that the court needs some assistance. The court doesn't need any assistance in making a ruling. You have a motion limine, they have a response, and then we had the no joinder, so I don't have anything from the water, and they've had no position on that. So realistically, it does seem to this court that I should rule today, because I see this as distinct from the issue that was brought up in a motion for summary judgment as the very first hearing yesterday versus today with the motion limitations. Things have changed both procedurally, and what I mean by it is now your firm has had the opportunity to review at least the stipulation, clearly knows what it says, and with regards to this actual motion, it's an evidentiary issue. It really wouldn't be changed by supplemental briefing, which may or may not occur depending on what the legal analysis is on a separate legal issue in a motion for summary judgment. So, and also I have to be cognizant of the dates and times, and right, and everything else the parties are doing and all your other deadlines, and whether or not this would be able to be done, and if there's any need for it to be done. And I heard the request, but I really didn't hear the reasoning. So for all those reasons, the court is going to find, and since you also asked me to rule today, the court is going to rule with ET&T's motion eliminating number 23 to exclude evidence or reference to hydrazine being in real water, retail bottles sold by Terrible Herbst needs to be denied for reasons, multiple reasons. One, the evidence has to come in one way or another to both sides. One side is going to want to say there isn't any, potentially, whether it's such a little amount or whatever you want to say. And the other side is going to want to say that there is. The issue before the court, based on the actual complaint in this case, is related to hydrazine in the water. And plaintiffs have a burden, right? Under the claims, you have defenses. Under claims, by definition, it's going to have to come in. And so there needs to be evidence. By definition, there has to be reference, because if it's a level of evidence, it needs to be referenced. And next, at this juncture, realistically, in light of the positions already taken by the parties, I don't see how the court could possibly exclude it, like I said, based on the claims and defenses in this case. So motion eliminating number 23 is denied. That is document 677. We're moving on to document 674. Document 674 is to exclude the Eurofins and FDA tests.
If I may request a brief comfort break, about 5 minutes.
Sure, but do you want me maybe at least to finish this, which one?
The motion.
Hold on, okay, no worries. Let's take a break, everyone wants a break, let's take a break. So it's 35 after, and we'll treat it as the 15 minutes, come back at 10 minutes of free. Does that meet everybody's needs?
Yes, sir. Thank you very
Thank you
much.
so
I
much. Have a great
apologize for interrupting.
Sure, no worries. Everybody ready to go back on the record?
Yes, Your Honor.
Yes, Your Honor.
Yes, yes, yes.
Yes.
Okay, great. Then what we're going to is we're going to your next one. So the next one is document 674, which is ETT's motion eliminating 19 to exclude Eurofins and FDA tests of water samples manufactured in 2020 and later. Opposition by plaintiff 804 and ETT's reply, document 943. Counsel for ETT, go ahead, please.
Joul Odou for Terrible Herbst. Terrible Herbst moves to exclude testing of water samples manufactured in 2020 and later. We briefed this issue in opposition to plaintiff's motion to pre-admit this, essentially the same evidence. We think the same ruling should apply here and should go a step forward. These testing results should be excluded in whole because they lack relevance to Hunwardsen's claims. These testing results were of water samples that were manufactured in a wholly different bottling facility. They were manufactured in Mesa, Arizona. The manufacturing facility where Hunwardsen would have drank retail bottles was Henderson. In addition to lacking relevance, the introduction of such evidence will prejudice Terrible Herbst because it will easily confuse and mislead the jury as to what these results stand for. They do not resemble the product that Hunwardsen would have allegedly purchased from Terrible Herbst and consumed. Thank you, Judge.
Thank you so much. Okay. Counsel for plaintiff, would you like to be heard?
I would, Your Honor, unless the court already has an inclination.
Actually, I'm sorry, just one quick one. Real water, I did not see that
Oh,
you
I'm sorry,
filed
Your Honor.
anything, so I just wanted to make sure.
Nothing yet. Or
Okay.
no position.
So the only portion of this motion would be as to Hunwardsen, because Real Water doesn't have a position, is that correct?
Correct, Your Honor, we agree.
I appreciate it, thanks so much, go counsel, I just want to make sure that point of clarification.
And I appreciate that, Your Honor. Again, Teddy Parker on behalf of the plaintiff. Your Honor, do you have any questions or inclination one way or the other? Because this seems to be one that should be denied. I say that most times when I'm opposing the other side. But, Your Honor, given what we've already discussed at length today and yesterday, by way of an example, the FDA testing has already been pre-admitted. I think it's been fairly explained that Hunwardsen's illness and symptomology occurred in 2019. The water that Hunwardsen would have consumed would have been done at the Desert Inn plant, not Henderson. And so defense counsel's chronology and description of the events is incorrect. The Eurofins testing, Your Honor, again, we discussed that yesterday. The Eurofins testing of bottled water was done in 2023, but it was bottles that had been manufactured years before, and it still had hydrazine in the bottles. And those bottles didn't have a Whole Foods label on it. It was all real water produced out of the same concentrate, which would go to sellers and distributors like ETT. So I just don't see that there's any factual basis that supports the ETT's position in this motion, Your Honor.
And just for a point of clarification.
Sure.
Counsel for ETT made a reference to yesterday's ruling. Now remember yesterday's ruling with regards to document 629, which was plaintiff's motion eliminating number 5, to pre-admit the Eurofins retail bottle testing, finding
Yeah,
the
which
hydrazine. The court denied without prejudice, thank you, only the pre-admission.
Absolutely.
The court did not make a ruling substantively excluding any evidence. I just want to make sure everyone's on the same page. So nothing I'm going to rule today is going to be different than that ruling yesterday. Okay.
Correct, Your Honor, and that's how I took it. Your Honor, pre-admission is one thing. Trying to prevent the Eurofins testing from coming out during trial was not the subject of yesterday's motion. The other thing I thought yesterday, Your Honor, I don't know if I was arguing the motion or not. Well, someone on our side was arguing it. When the defense attorneys for ET&T tried to suggest that the Eurofins testing, I think it was yesterday, was not relevant, it was relevant enough for the other distributors and sellers to actually request to do the inspection. And I want the court to know, and I think this was said yesterday, but just in case, I want to make sure if it wasn't said, I say it today. Those bottles were taken from the warehouse based upon a protocol established by the special master and approved by the court. The bottles were tested by Eurofins, Mr. Neslin's deposition was taken, and those bottles showed hydrazine. And so, given what we know about this case, Your Honor, certainly that testing is relevant. It exemplifies that the retail bottles, just like the jugs, the 5-gallon jugs, contain hydrazine, Your Honor, and certainly should come in.
Okay, appreciate it, thank you.
Thank you.
Counsel for ETT, you get last word, guy, please.
Jan Tomasik from Terrible Herbst. Judge, I did misspeak. Mr. Parker was right. The manufacturing plant was Desert Inn, not Henderson. But even more so, that highlights the point that we're trying to make here, is that just by virtue of the fact that there was testing done does not mean that it's relevant to Hunwardsen's claims whatsoever. There's more differences in the product testing than the product that Hunwardsen claims injuries by. I mean, there's years of difference. These things were manufactured by different people on different lines in different bottling facilities. So the argument that this testing was done and therefore it's relevant, it doesn't work. There's obviously reasons why they tested the product. It's because plaintiffs alleged injuries from product made in that time frame. There it would be relevant. Here it's not contemporaneous in the least bit. there are more differences than similarities, and therefore it should be excluded.
I appreciate it. Here's the court's ruling, and consistent, nothing in the court's ruling today in any way modifies the court's ruling yesterday with regards to document 629, which was plaintiff's motion eliminating number 5, nor any other ruling of the court. But the court is going to deny document 674, ETT's motion eliminating number 19 to include Eurofins and FDA tests of water samples manufactured in 2020 and later. Somewhat similar to the court said yesterday is really this is going to have to be evidence and testimony to see what comes in, what is appropriate. It really goes to weight. It doesn't go to inclusion or exclusion. And a lot of the arguments on what the jury may or may not think is really going to be up to the triers of fact of the jury. So the court needs to find, adopting the case law set forth in the opposition, the court denies ETT's motion eliminating number 19 to exclude Eurofins and FDA tests of water. Moving on next to document 625. ETT's motion eliminating number 2 to preclude plaintiff's expert witness, Dr. William Hudson, from testifying that the retail bottles of real water sold by Terrible Herbst contained hydrazine and were a substantial factor in causing Myles Hunwardsen's liver failure. Court's opposition is document 865, reply 963, and nothing by real water. The court does have an inclination on there. The court's inclination is to deny the motion realistically has been presented in several of the other motions and the totality of the briefing, including the briefing on this specifically, the briefing on this as well, is that he has the hallmark bases. Whether the jury agrees, disagrees, and how they view the weight of that really would go to the weight of his testimony, not preclusion with regards to his causation and his liability theories. And the court in this one, that's its inclination only. Counsel for movement, go ahead, please.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst. Your Honor, this motion was fairly limited, and that is a request to exclude Dr. Hudson's opinions concerning hydrazine being in the retail bottles that Terrible Herbst sold. And the reason for that is his testimony, which is referenced on page 6 of our motion. Your Honor, when I asked Dr. Hudson directly whether the real bottles that Terrible Herbst sold contain hydrazine, his response is, I would assume so, because the concentrate is the same. Concentrates made the same for the retail bottles in 5-gallon jugs. I then go on to ask him whether I misunderstood, and I asked, did I misunderstand that there were some safe bottles of real water that had been made? His response, no, you heard it correctly, but we don't know which. All of the bottles that were contaminated and all of the bottles that were not, right? So my next question, which was, I believe, the standard that must be met in this case for an expert to render causation opinions, my question was, so how can you say to a reasonable degree of medical probability that Mr. Hunwardsen consumed real water bottles from Terrible Herbst that caused his liver failure? And his response is, well, I think since the concentrate was the same between the 5-gallon jugs and the retail bottles, I think it's a very safe assumption to say that the retail bottles had hydrazine in them just the same as the 5-gallon jugs did. The problem is, an assumption is not the same as stating an opinion based upon a reasonable degree of medical probability or scientific probability. But not only that, it somewhat contradicts his own testimony. On page 6 of our motion, I eclipsed his testimony and asked him, and in your opinion, doctor, why didn't Mr. Hunwardsen get sick in 2016? He then states that, well, I think there's multiple reasons. I think one thing about the concentrate, not every concentrate was made the same. And that's been shown. I think that some concentrates were perfectly safe. There was nothing wrong with it, and I think other concentrates were made erroneously or made wrong, so that they were toxic and generated hydrazine. The problem with Dr. Hutt's testimony, Your Honor, is it's going to be given a lot of weight because he is an expert. But at the same time, he's making his opinions based on assumptions. And I don't believe that you can make a medical opinion to a reasonable degree of medical probability just based upon assumptions without sufficient evidence. There must be some foundation for those opinions. And if he's just going to be making assumptions, that's insufficient. He needs to be able to state to a reasonable degree of medical probability that Mr. Hunwardsen's liver failure was caused by Terrible Herbst retail bottles. And he didn't do that in his deposition, and therefore he shouldn't be able to come into trial and do it now. That's why we brought this motion. So at the very least, I think he should be precluded from offering those causation opinions and stating to the jury that hydrazine was in fact in retail bottles sold by Terrible Herbst. That would be a contradiction to his deposition testimony. I think he's bound by that, and I also think it's insufficient. So for those reasons, Your Honor, we would ask that the court exclude Dr. Hudson from testifying that there was in fact hydrazine in Terrible Herbst retail bottles. They have other experts who are going to come and testify, but Dr. Najm is a causation expert. He needs to be able to state that. He's a physician, and he cannot do that.
Counsel, did you maybe switch to Dr. Najm, is a medical expert? I'm not sure.
No, he's not Dr. Hudson.
Okay, no, I thought you said Dr. Najm. I just want to make sure we're talking about the same one. Go ahead, please.
And with that, Your Honor, that's all I had. Did you have a question?
I do not. Appreciate it. Thank you so very much.
Thank you.
Counsel for plaintiff, you have an opposition there too.
We do, Your Honor. And, Your Honor, after hearing the argument, I really don't know why the court would change its inclination. Questions were asked of Dr. Hudson regarding formulation or creation of hydrazine in real water. That's not what he was retained to do. I put on the screen just so the court could see it and if I need to refresh the court's recollection, I could put it back on the screen. But Dr. Hudson's opinions as a hepatologist, as a gastroenterologist, is that hydrazine caused these plaintiffs' injuries, acute liver failures in these plaintiffs. And the questions asked by AT&T's counsel was whether or not any of the bottles ever created by real water did or did not have hydrazine. That's not the question that this doctor has been asked to render an answer or an opinion on. The question is whether or not these plaintiffs, having suffered acute liver failures, were those acute liver failures caused by the consumption of real water, which included hydrazine. And that's the opinion he's given. We don't intend to ask Dr. Hudson, do you know how the electrolysis process ultimately created hydrazine in the real water bottles? That's not a question we'll ask him. So, Your Honor, I believe your inclination is correct. I do not believe that Dr. Hudson, in terms of his opinions, written and his deposition testimony, his deposition was taken twice, Your Honor, has changed or varied his position in terms of these plaintiffs. And so for those reasons, Your Honor, I think the motion should be denied.
Okay, appreciate it. Thank you. Real Water, I didn't see that you had any position on this.
We have no position, Your Honor.
Appreciate it. Thank you so much. Counsel for movement, go ahead, please.
Thank you, Your Honor. Just briefly, it seems that, if I'm understanding correctly, that Dr. Hudson is not going to be testifying that there was hydrazine in the retail bottles sold by Terrible Herbst. But perhaps I just misunderstood what was just said. Because if that's the case, then I think we have a stipulation on at least the first part. Maybe not the causation opinion, but at least on whether or not there was in fact hydrazine in the retail bottles sold by Terrible Herbst. I think at least that opinion should be excluded.
Counsel for plaintiff.
Your Honor, I'm sorry. Your Honor, I placed before not only the court, but ETT's counsel, the opinion of Dr. Hudson. In terms of plaintiff Hunwardsen, if I could approach, Your Honor?
Sure.
And I guess I'll read it this time. I read only the second sentence the first time. But it says, Myles Hunwardsen developed acute liver failure secondary to, i.e. caused by, the consumption of both 5-gallon and retail size real water. The acute liver failure required this patient to have a liver transplant. Mr. Hunwardsen's consumption of real water from 5-gallon bottles and retail bottles were both substantial factors in causing his acute liver failure and subsequent need for liver transplant. Your Honor, as a part of this opinion, and we can go to the top first page, Dr. Hudson describes the pathology and how the toxin, hydrazine, caused the liver damage. So I don't know where ETT's counsel is confused, but he did a differential diagnosis to make sure he ruled out all other etiology. And he says right here, real water and hydrazine. I mean, he discusses it and how hydrazine caused the liver injuries and how the pathological reports are consistent with this toxin doing that damage, causing fibrosis and scarring within the liver. Any questions, Your Honor?
My only question is I'm not sure you two are on the same page as what is being asserted with regards to Dr. Hudson, but I think, let me see if I can maybe get a clarification. Counsel for Terrible Herbst, in light of counsel for plaintiffs setting forth again what he's intending, do you see, obviously you disagree on the causation aspect of it.
Yeah, that I understand. We're disputing the causation. My only issue is he going to come here and testify that hydrazine was in the retail bottles sold by Terrible Herbst? We just saw his report. He says retail bottles in general, which I understood that, but that's why I asked the question specific in his deposition.
But I think the distinction you all are talking about is he going to use the words Terrible Herbst in his testimony? Does he know where Mr. Hunwardsen bought said bottles, or is he just going to say wherever he bought them, or more eloquently, but wherever he bought said bottles, he ingested both retail and 5 gallons, and that was real water, and that then caused his liver failure, or words more eloquent than that. So is he going to?
He's going to say that
Terrible
because
Herbst.
he's going to say that, Your Honor, because he also has the fact sheets and he did the interviews of each of the plaintiffs. So he knows, based upon their representations, the time of consumption, where they bought the retail bottles. He knows that information. And he's going to say, just like even the defense experts will say, that because the concentrate was the same, be it retail or jugs, they all had hydrazine in it in terms of these plaintiffs. That's one thing that the court has made clear based upon yesterday's conversation and arguments. We're talking about these plaintiffs, we're talking about their consumption, and that's how we've approached or addressed these motions, Your Honor. And so he will be able to say that based upon his interview with Mr. Hunwardsen and the fact sheets that each plaintiff had to fill out.
And as far as the fact sheets, he'll make a distinction that this is based on the fact sheet that he's been provided or in speaking with Mr. Hunwardsen. Also to that that's
Sure.
not the independent investigation that he did.
Exactly, Your Honor.
Okay, so counsel,
I think I'm still confused, Your Honor. It sounds like he is going to say there's hydrazine in Terrible Herbst retail bottles.
Yes.
Okay,
Based upon fact sheet, the interviews, his own experience, everything that we discussed in terms of meeting the hallmark requirements and qualifications, yes, he will say that.
And that's where I have the issue, because I understand he's going to make a generalization about retail bottles in generally causing these plaintiffs' liver injuries. But we're talking about Terrible Herbst here, and it sounds to me like he's making an assumption. Because I just read you his testimony, he is making an assumption, and that's not the standard for expert testimony.
Can I address it? I'm sorry, I
what I was
apologize.
going to ask you to do is to please put up the
Yes.
section of the deposition testimony that you previously referenced, right, that was highlighted in yellow, if you wouldn't mind. Because I think in the question, there was a statement made which the court wants to clarify exactly how that question
Laid
was
out.
phrased. So,
And while she's looking, Your Honor,
Page 6 and
I take exception to that general proposition. Your Honor, every day in this court and every other department, on a standard PI case, doctors interview and examine plaintiffs. And they give testimony and opinions based upon those examinations and those
Some
interviews.
notes, I'm aware of them.
Thank you, Your Honor. This is a part of what happened here. This was an interview, a review of records, medical records, to come to this conclusion. And so for ETT's counsel respectfully to suggest that this doctor can't give an opinion based upon an interview, review of medical records, and fact sheets seems at odds. But I am look forward to seeing how precise the question was in terms of the deposition.
Yeah, let me take a look at the deposition one that you referenced, then what the court would rule. Does anyone have an objection to asking Mr. Godfrey or whoever's running the controls to put the question back up on the screen?
We have somebody here who's going
Okay, I don't know who was doing that particular one.
Mr.
Zamora.
Mr. Zamora doing it. Like I said, I wasn't sure who was doing it. Whoever was the magic person putting it up on screen. Does anyone have any objection to the court asking and looking at it again?
Your
An objection from real water.
Do you have any objection to the court looking at that again?
Oh, no, Your Honor.
That's what I'm asking. I wasn't gonna do it if somebody was gonna object. Okay.
And Your Honor, just to clarify, we're not arguing that a doctor can't make opinions rendered on soap notes, etc. What I am arguing is he's made an opinion already in his deposition. It would be wrong for him to come into trial and change that. And he would need to change that because this is not the standard by which he can render causation testimony. That's all.
No worries. So I'm understanding what you're saying. The reason why the court wanted to look at this is because my recollection is consistent with the way this question was asked, right?
Okay.
Read the way the question was. And I might need to go a question above it. So the question says, right. So how can you say to a reasonable degree of medical probability Mr. Hunwardsen consumed real water bottles from Terrible Herbst that caused his liver failure? Contained in that question is the assumption, right, on the plain language from a neutral third party reading it, that the doctor has already made a opinion to a reasonable degree of medical probability that Mr. Hunwardsen consumed real water bottles from Terrible Herbst that caused his liver failure. So that's why the context of the question is very important. So I'm reading his answer, but I have to read his answer based on the way that question was phrased. Because remember, I'm a court reviewing it for purposes of a motion to eliminate. I'm not part of the jury preamble instructions, however you'd like to phrase it, where we talk the distinction between a question and what's actually evidence in the answer. Here, I have to look at the context, because you're asking me to evaluate his response. So I have to look at the context of how the question was asked.
Understood.
So in the context of how this question was asked, it's going to be part of this court's ruling in just a second. Just want to make sure you had a full opportunity to give your final word if you wished it.
Yes, I mean, I asked a specific question because we know he's made general opinions to a reasonable degree of medical probability. I have no issue with that. The issue comes when we get specific to Terrible Herbst. He didn't make that opinion specific to Terrible Herbst retail bottles in his report. He's making a generalization about all retail bottles, and as we know, Mr. Hunwardsen consumed retail bottles from multiple places, including from Whole Foods and other major stores. So my question was trying to get to Terrible Herbst in particular, and he could not say that. Now maybe he could say that for Whole Foods or UNFI, who had some testing done, but he was unable to say that, not only because there was no testing, but he had to take into account Mr. Hunwardsen's history with real water and consuming retail bottles. And we can certainly scroll up further, Your Honor, if you need that context, but this all started because I asked him, how come he didn't get sick in 2016? And that's when he came up with the opinion that not all concentrates are made the same. There were some that were safe, and that's why we have an explanation as to why Mr. Hunwardsen doesn't get sick until at least 2018 and eventually in liver failure in 2019. So I was trying to get to the specifics. He's making generalizations. All I am saying is for him to come into trial now and change that from an assumption to a reasonable degree of medical probability specific to Terrible Herbst would be wrong. And if you allow the assumption testimony, that's an improper expert opinion. The jury's going to give that substantial weight coming from this expert. And it doesn't meet the standard, which is to a reasonable degree of medical probability. He says that in his report, I grant you that, but it's very general as to retail bottles all over. And I don't think that in a products liability case, you can prove causation as to a specific retailer by saying all retail bottles for all time, and then saying that some were safe. There's no foundation for that when you're saying that some are safe and some are not.
I appreciate it. Thank you so much. Okay, considering everything in the additional argument everybody got, can you keep that up there for a moment, please? Because I'm going to quote from that in just a second, if you don't mind, please. Court is going to deny document 625 ETT's motion limiting number 2 to preclude plaintiff's expert witness, Dr. William Hudson, from testifying that the retail bottles of real water sold by Terrible Herbst Blushes contain hydrazine and were a substantial factor in causing Myles Hunwardsen's liver failure. Let's go to the first part. The first part is a two-pronger, right? So the first part is testifying that retail bottles sold by Terrible Herbst contain hydrazine. The listed part of the argument why it's asking that for conclusion rather than wait is setting forth part of his deposition testimony, but with the deposition testimony at issue, it subsumes the question in it. The court has to look the way that question was asked. Since the question was asked, so how can you say to a reasonable degree of medical probability that Mr. Hunwardsen consumed real water bottles from Terrible Herbst that caused his liver failure? Answer, well, I think that since the concentrate was the same between the 5-gallon jugs and the retail bottle, I think it's a very safe assumption to say that the retail bottles had hydrazine in them just the same as the 5-gallon jugs did. He answered the question that was asked. That in and of itself is not reducing his opinion because the question assumes that he already made an opinion to a reasonable degree of medical probability because that's what it says. And so the court can't say somehow he's done a lower standard and doesn't meet hallmark based on that depo excerpt. Taking the totality of what is presented in the motions of the other deposition experts, similarly, that really goes to weight, okay? Because there's nothing that he is precluding in his report. Since there was the opportunity to do the deposition follow-up to clarify whether he meant all retail bottles or retail bottles from certain locations, including or excluding Terrible Herbst, that opportunity was there, the questions that were asked, and there's nothing that shows that he has changed an opinion, made an opinion that doesn't fall within hallmark. So realistically, the court sees that his testimony goes to weight rather than exclusion, or preclusion, however you'd like to phrase it, and so therefore the court denies ET&T's motion eliminating number 2. It is so ordered. Now, we still had on for today, remember the court had deferred on plaintiff's motion eliminating number 11, which was the one on the instructions on products liability for today.
Your Honor, I had that deferred till Friday.
Oh, you have it till
Given
Friday?
this
Okay, well,
stipulation.
you all have a choice. We can do it tomorrow, we can do it today. If you want to be done for today with regards to the motions or not, we have time, we can get through some more motions. The court's prepped for them, so it's really up to you all what you all would like to do. Because if you don't want to do that one, if you're anticipating that one's for tomorrow, but yet you're prepped for trying to do the next two in order, which would be the clinical pathology reports, we can do those.
Let's do those, Your Honor.
Or if you want to do the rev check testimony, because real water, that would be parallel to what the court's already ruled in something related to yesterday, I could do that. Or if you all were only prepared for what we've already gone through, because those were the 11, then we can stop there. I can address some of the questions raised by counsel for real water and other counsel's questions on some other areas. Realistically, folks, the court's fine either way. I'm prepared for them. If you want to move on, if you all want to stop on the motions because of your preparations, then we can stop on the motions and we can address a couple of the outstanding questions, i.e. including the depot designation question.
Judge, we're ready to do the path if the other defendants, I'm not insisting to be done, it's their motion. If they want to do it, we could do it.
I'm sorry, I didn't hear you, Mr. Kemp. The pathology motion?
Yeah.
It was
So you can do
document
the pathology
615 and
motion.
672.
There's actually 2 of them.
Yeah, we could do, Real Water is prepared to move forward on, looking for the document number
615?
615 and 672.
And we're prepared to move forward on pathology as well. I just need to look at the filed stipulation again before 11, before I can argue MIL number 11.
Well, that's fine. We'll put that till tomorrow. That's fine.
Great, thank you, Your Honor.
No worries, like I said. Let me put that on my tomorrow stack. So this is going to be contact for Friday. Okay, and everyone's Wednesday. Okay, well then if there are request parties, we'll keep going. Let's get a couple more done. Document 615, Real Water's motion elimination of approved pathology reports and results from non-plaintiffs. And counsel for Real Water, since it's your motion, go ahead please.
Thank you, Your Honor. Joul Odou on behalf of Rural Water Infinity. This actually should be a brief motion. I don't know, maybe famous last words. Rural Water has sought to exclude the pathology reports of non-plaintiffs to this case. Dr. Brian Datnow has offered opinions on pathology reports of a number of people, Myles, Hunwardsen. We're not challenging the pathology report of Myles Hunwardsen, to be very clear. We believe that since liability and causation is not at issue, that doesn't affect this motion, but it does, to some degree, further affect the other people and other pathology reports that plaintiff seeks to introduce, making them further prejudicial. Let me be very specific. The pathology reports include James Hugh, Kathleen Ryerson, who were in the Gallagher case. As the court may or may not be aware, Kathleen Ryerson passed away from the consumption of real water. Introducing her pathology report couldn't be more prejudicial. The plaintiffs in their opposition say, oh, it's not prejudicial to introduce this evidence. It's really hard for the court, I would imagine, to fathom how something could be more prejudicial.
Counsel, your colleagues are talking, which means the microphone's going to them and it's very hard to hear you. You might want a clear record. So
Thank you, Your Honor.
Apologize.
That's all good.
just if you're going to do it, at least push down so we're not picking up the microphones, right? And
I apologize, Your Honor.
no worries.
Kathleen Ryerson passed
Ryerson
away
passed away. You mentioned it, the spiking. Yes, I've heard it.
from the consumption of real water. There's nothing more prejudicial. It's not possible. To allow the plaintiffs to introduce evidence of Kathleen Ryerson's death in this case, starting with the pathology reports and ultimately concluding with how she passed away, there's nothing more prejudicial. It would completely taint this jury. This jury is tasked, at least as far as the real water defendants go, with awarding reasonable damages and following the court's instructions on those. Nothing could inflame the passions more than if we start departing from the plaintiffs in this case and talking about deaths, talking about infants, talking about things that are not part of this case. James Hugh suffered liver scarring, and the jury heard that evidence, and the jury was sympathetic to Mr. Hugh. And to introduce Mr. Hugh's injuries in this case are also incredibly prejudicial and improper. Bruce Patent and Henry Tecante are plaintiffs in other cases. Again, to introduce their claims in this case not only is prejudicial, it's incredibly prejudicial. There is nothing that could be worse than to try and introduce evidence of other injuries in this case which are not relevant. We can certainly argue about that. We have other motions in limine coming up arguing about that. But let's stick to the subject of this motion, which is the pathology reports. Plaintiffs have offered no compelling evidence as to why pathology reports of non-plaintiffs would be admitted in this case and commented upon by Dr. Datnow and likely Dr. Hudson.
Okay, one point of clarification with regards to it, the distinction between the actual reports versus, well, there is a dispute of what can and cannot come in for the notice concept and whether, right, that we're not hitting there. But I saw your motion specific to actual reports, not addressing that broader concept. Is that correct or incorrect?
It is the pathology slides, the report, his opinion as to other plaintiffs. Certainly that's inappropriate. The motion was targeted at the pathology of these other people. To introduce that in this case is highly prejudicial. Basically, to try and keep it brief as I promised I would, when you get to those pathology slides, there will be testimony as to what the slides mean, how the injuries are severe as to different people. It just becomes a complete amount of overwhelming evidence to the jury about other injuries, other people, and it takes the focus away from this case, which are the serious injuries of Myles Hunwardsen. And for those reasons, we think these other pathology reports, slides, should be excluded, and we would actually go further, and we have other motions that talk about excluding the testimony of other injured parties both before and after the injuries alleged in this case.
And should we be addressing from your viewpoint 615 in combination with ET&T 672?
Yeah,
The reason
yes,
I might do
Your
that a
Honor.
little bit out of order is because since I have two different move-ins, if you want to address that one, I think
I have nothing further to add. We joined in ETT's docket 672.
Okay, thank you. Then ETT lets you go next, both to your substantive and your joinder, then plaintiffs, you can respond to both. Okay, thank you. Go ahead, please.
Thank you, Judge Young, Tomasik for Terrible Herbst. We joined in the arguments shared by Mr. Odou. We spelled out that any evidence reference to or testimony regarding that now's opinions of non-plaintiffs' pathology reports is irrelevant, prejudicial, confusing to the jury, and must be precluded. In allowing evidence of subsequent plaintiffs, we interject collateral issues here, and this really is an extension of the issue that was brought before this court yesterday with the Wren documents. DeConte Henry is another plaintiff pending before this court. Expert opinions have not been set forth. Discovery is still in its infancy, and therefore it would be, prejudicial to allow these pathology reports to be shown to the jury, and we'll submit on that.
Appreciate it. Thanks so much. Counsels for plaintiff, who's handling this one? Go ahead, please. Can you address both 615 and 672, the ones
Yeah,
for
sure.
the water and ETT? Thank you so much.
Your Honor, first of all, there's only 5 plaintiffs, and I think there's one, I think we got some slides from Daisy Weed a while back. But there are 5 plaintiffs who Dr. Dadno looked at their slides. You remember, we can't get tissue slides from everybody because most people, including the 5 babies, didn't have tissue taken, because the reason for that is they don't want to do a needle biopsy of the liver unless they really got to, because it's a very invasive surgery and it does have some risks. So we have slides from 5 different people, one of which is Mr. Hunwardsen. So the slides are from James Yu, Ryerson, which is one of the probable 2020 cases. The Southern Nevada Health District has determined that's a probable case, Mrs. Ryerson. We have Hunwardsen, we have Mr. Parent, P-A-R-E-N-T, and we have our DeQuante Henry. So the opinion here is nothing more or less than that what is being seen on the slide is consistent with hydrazine toxicity. It is not saying that, and that's primarily the steatosis. And both of the experts have seen the slides, and by the other expert, that's Dr. Gong, that's the pathologist for Terrible Herbst. They've both seen all 5 slides. Dr. Datno filed this exact same report in Gallagher that he has in this case. And all he is saying is that what he saw in the 2020 slide of Ms. Ryerson, Mr. Yu, Parent, and Henry was a little earlier, 2020, I believe. But it's the same thing that he saw in the Hunwardsen slide. So the reason it's relevant is because defendants are taking the position that something different happened in 2020. This shows that these other plaintiffs had the exact same injury. And it's not conclusive that it was caused by hydrazine. I don't want to mislead the court. There's no magic marker in these slides that say it had to be hydrazine, but it is consistent with hydrazine toxicity, the path findings on these 5 plaintiffs. And Dr. Gong conceded that as to at least Hunwardsen, that is consistent with hydrazine toxicity. So the relevance is that we want to show that a probable case had the exact same pathological finding as Mr. Hunwardsen. That's the real key here, comparing it to the Ryerson probable case. And it's not our intent to, I don't even have to say it's the death case, Your Honor. We can try to dance around it, call it patient 1, 2, and 3, whatever. It doesn't, I don't have to use people's names, but I do have to say that it was one of the probable 2020 cases, and that they found the exact same thing on the pathology slide that they found in the Hunwardsen case, because that is powerful evidence. That is powerful evidence that the CDC and the Southern Nevada Health District determined that this probable case was caused by real water, specifically the hydrazine, and that case has the exact same symptomology on path slide as the Hunwardsen case. That is very powerful evidence, and that's why they're trying to exclude it. And Mr. Odou expressed concerns about potential prejudice. Like I've already said, there's ways to address that by not referring to it as a death case, not even using the name Ryerson. There was really no attempt here to introduce the pathology reports themselves for these specific plaintiffs. Dr. Datnow has reviewed them, but those are not exhibits we intend to offer. All we intend to offer is his testimony that he has seen on these slides, injury that's consistent with hydrazine toxicity, and to be a little more specific, that would be the steatosis, which Dr. Gahn also admits she saw on the Hunwardsen slide, the steatosis, and that he's also seen the same thing on the other slides. So that is the point here, and it goes squarely to causation, because, like I've already said, what better proof of causation than that you found the exact same thing on the past slide of the probable 2020 case as you did on Mr. Hunwardsen? What better proof would there be?
Okay, so let's walk through causation.
Okay.
I got two separate motions, right?
Right.
Real water is 615 and ETT 672. With regards to real water, given the stipulation, your only causation person is Brody, so how does it relevant to Brody?
Well, it's not relevant to Brody because there's no slide on Brody. It wouldn't be relevant on Brody.
So, because real water is asking for it to be precluded, right?
Right, they're asking, but I think they're asking for it to be precluded not because of causation. They're asking for it to be precluded because they think reference to other plaintiffs, particularly a death case in here, would potentially be prejudicial. And I'm agreeing not to do that. I think there's a way to make this a little vanilla, that it's a 2020 probable case. You looked at the slide, we can do that. That's not a problem. But to say that he can't say that Hunwardsen has the exact same symptomology based on his pathological exam as a probable case that the Southern Valley Health District, the CDC, has determined, that, especially when they're trying to draw the distinction between the retail bottles and the 5-gallon jugs.
Okay. Let me hear from each of the parties in their final words. I'm going to go to real water first because yours is a little bit nuanced difference. It's in light of some of the statements by Mr. Kemp with regards to addressing some of your issues. Let's see if you saw an issue. Go ahead, please.
Thank you, Eric. We don't believe that goes far enough. If you go, even if the plaintiffs were to say, the plaintiffs' attorneys were to say, we're not going to talk about the death case, this is still highly prejudicial. Let me use Mr. Hugh as an example. Mr. Hugh's slide shows liver damage that Dr. Hudson testified and would be expected to testify in this case is potentially a game changer. Those were words that went like electricity through the prior jury, and they will go like electricity through this jury as to the severity of being exposed to hydrazine. We don't have, in this case, a slide from Plaintiff Sosa or Plaintiff Brody as an example. And so to use that type of argument, look how badly this person in this other case was injured. When you consider the injuries in this case, that's prejudicial. As to Myles Hunwardsen, they say, oh, well, it's powerful evidence that Kathleen Ryerson died and Kathleen Ryerson's slides are so severe. Myles Hunwardsen had his liver transplanted. He had his liver removed. I don't know what more is powerful evidence. The plaintiffs acknowledge that Terrible Herbst expert even agreed that he saw the same things that Dr. Datnow saw on the slides. So there's not even a dispute as to the evidence. I heard plaintiffs' counsel just say Terrible's expert saw on Myles Hunwardsen's slide and agreed with the findings of Dr. Datnow. Now, I haven't compared the opinions side by side, but I would note that in response to this motion, they haven't challenged that anybody is saying Dr. Datnow is wrong as to Myles Hunwardsen. And that's really the heart of the issue, is they say we have to support Dr. Datnow's opinion because it's being challenged with these other people that he looked at. I don't see the evidence that his opinion has been challenged, in particular as to the slides. The slides are what they are. They're objective evidence of liver injury. introducing other slides of other patients just completely undermines the purpose of this trial, which is reasonable, common reasonable damages, which is the jury instruction for this jury as to Myles Hunwardsen, and that blows it up.
Not a stick of dynamite today?
I'm sorry,
Not a stick of dynamite today?
not today.
Okay.
Nah, I don't want to get a call from the government.
Okay. Yesterday was a dynamite stick, today it's blowing up, we're good, okay.
Thank you.
Thank you, counsel. Counsel, go ahead, please. On behalf of ETT Terrible Herbst.
Thank you, Judge. Judge, allowing these pathology slides of non-plaintiffs to come in would essentially put a burden on the defendants to put on a trial within a trial, case within a case. For example, one of these subsequent plaintiffs, I won't mention the name, it's clear that he had pre-existing liver cirrhosis, and that's going to come up on the pathology slide. So are we going to sit here and argue a trial within a trial to a subsequent plaintiff where there has been no expert opinions, depositions, discovery completed? It would be unduly prejudicial to the defendants to do such. Furthermore, I think Nevada case law is clear on this issue, Hansen and Rivas, that we should avoid injecting collateral issues to prolong the trial and confuse the jury. Basically what plaintiffs try to do here, they only cite to Beatty and Guinness for the proposition that the proffered pathology reports are admissible in this case as evidence of prior or subsequent accidents. But here they're putting the cart before the horse in that the jury would have to assume that all of the same facts and circumstances led to those injuries and go backward from that. It's backtracing and it's prejudicial. Thank you, Judge.
Here's the court's ruling. Document number 615, Real Water's motion limited to preclude the pathology reports and results from non-plaintiffs. It is granted with a small carve-out. If there's an opening of the door asserted, then that's going to need to be brought to the court's attention outside the presence of the jury, and the court can address whether or not something comes up that would have to change it. Realistically, the court does find, similarly, document 672, AT&T's motion limited to exclude pathology reports from non-plaintiffs. The court's also going to grant that. With the same carve out, if somebody feels there's an opening in the door, it needs to be brought to the court's attention outside the presence of the jury. The court's analysis is that it is not relevant. See part of my analysis from RAM yesterday. See the court's adopting the motions and the replies of the moving parties at 615 and 672. Realistically, you're potentially impacting even another case that's before this court, the Henry case, and other cases. I can't impact potential other cases by having certain things admitted, certain things discussed that aren't for this case, consistent with the court's prior rulings on both sides. We want to keep it to this case, we keep it to these plaintiffs, this case. So I do not find it as relevant. I also do find it is more prejudicial than probative for what is currently presented to this court. Not only with regards to Real Water and their arguments, but with regards to their claims, their defenses, and the status of their case. The only causation, which causation was one of the statements of why it should come in, is, the court's not agree, but if you look at causation with regards to Real Water, they've admitted causation everyone other than Brody, and there's no basis for how this would come in with regards to Brody. So then you look at how it would come in for Hunwardsen, potentially for the other aspects of the claims with regards to Real Water, and then the complete aspects of all the aspects of the claim with regards to Terrible Herbst. I think it could cause too much also confusion to the jury of who actually are the plaintiffs, what actually is the asserted injury of each of these plaintiffs in this case. And so for all those reasons, the court grants 615 and grants 672. It is so ordered. Do you all want me to go to Rev. Chuck's testimony, since we already addressed part of that concept yesterday, or do you want to stop for the end of the day?
We're pretty neutral on this one, Your Honor, so Mr. Odou, choice.
Which motion, which
So,
document?
document 622, Real Water's motion limited 14 to preclude Rev. Chuck testimony. It's fine for tomorrow, or we can do it today. You all choose, because it was not set initially for today. So if anyone feels that you'd rather it be put for tomorrow, it'll be put for tomorrow, it's fine.
Your Honor, we moved to exclude Dr. Rochek completely, and I didn't see an opposition.
Does anyone contend that they filed an opposition?
I thought we filed an opposition, Your
Can you
Honor.
tell me the document number, please?
I don't have that in front of me, but if I could have.
Is this a stay tuned until tomorrow then, since it was on
If
teed
we
up for
can,
today?
please, Your Honor.
Pardon?
If we can, please put it over to tomorrow.
That's fair.
Aaron, we have no problem putting it over, but we did also file the notice of non-opposition.
I'm aware of that, but that's why, just in case, since there's been other things that maybe not have been filed. Okay, so as far as your motions, let's walk through what we're doing tomorrow. Tomorrow, we're going back to Plaintiffs 11. We are going to be doing Real Waters, motion limiting number 14, which is document 622. We are doing document 620, which is Real Waters comparative negligence. We're intending to do document 655 E&T's number 4 regarding the rent action, to the extent that you all feel that there's still something left there versus what the court already ruled on. So, and I appreciate once again the distinction between exclusion and pre-admission, but once again, so that's what we're doing also tomorrow. Also doing document ET&T's motion limiting number 20 for document 675, document 611, which is motion limiting number 3 from Real Water regarding reference to other claims, lawsuits, settlements, and judgments. And if you're following along on the December 1 letter, I'm pretty much towards the bottom of page 2. And so document 617, also customer complaints, which is 617 is Real Water's motion limiting number 9, and document 618, Real Water's motion limiting number 10. And was also intending to do document 646, PTT's motion limiting number 10 to non-liver related injuries and non-plaintiffs, to the extent that parties feel that there's still things that need to be addressed with regards to that. And getting, actually, then 653, unrelated consumer complaints, 616, which is Real Water's motion limiting number 8 regarding limiting lay testimony, document 672, Real Water's motion limiting include lay witnesses from providing medical opinions, ET&T's motion limiting number 5 to exclude medical causation opinions by lay witnesses, and that is where there was hope we might get to, I better say 671 as well, exclude evidence reference to testimony relating to alleged injuries sustained by Blaine Jones. And I thought the parties might be speaking before tomorrow on that in light of the court's prior ruling with regards to Blaine Jones as a plaintiff, so I'm not sure if that's going to get modified. Remember, Mr. Odou said he was going to take up the aspect about whether or not you all are going to reach some kind of agreement. I'm not sure if you had that chance or not, but we can address that tomorrow. And that's what I showed getting us to tomorrow, which is about 14 motions, is what I saw was getting through for tomorrow. Does anyone think that that's not ambitious enough, or?
But that's plenty ambitious, Sharon.
Yes, Judge, especially for me to 3:30, you said?
3:30 was hopeful, no later than 4, okay? Well, realistically, you should know some of these are lay witness issues. They're really kind of combined, so I didn't see that significantly long. Some of these have already had some on certain aspects ruling, so. Okay, so that gets us up to there on 14, for 14 motions for tomorrow. And then, anybody have questions about those? If not, I'm moving on to,
Judge, can we, just to make sure we have them all exactly, can we have
Yeah,
the
sure.
numbers one more time?
okay.
Number one,
If you all reference Mr. Pepperman's letter, right from December 1,
Mr. Pepperman was the one that just asked me, so.
Your Honor, I apologize, I've been going off the more recent
I
letters.
can't do that one because you all didn't give me a red line which shows which ones were or were not, so I have to go off the original one because that's how we were doing
Yeah,
this.
I was just missing docket numbers on 3 of them.
Yeah, no worries, I can restate it. I just was gonna tell you, since it was you all's document, it went up to document 40, which is listed on the they're not numbered, these pages aren't numbered, 1, 2,
I got a copy.
page, document 40, right? You put numbers, so it was the 40th one, which was 671. So I can go back, which, you want me to do the last 4 again?
Number one, I didn't have the number on.
I'm sorry. The first one I was doing
Number
plaintiff,
11.
the very first, I don't have a document number on plaintiff's 11, because that's not on
And the
this.
fourth one was AT&T number 14.
I'm sorry. You know what, hold on a second, I can go back to that, give me a second, just 1 sec. That's the one I deferred, let me look at my notes, 1 second, please. That was the strict liability, pre-instruct on strict liability standards is what the,
That's
what
the
the name was.
instruction.
That's document number 663, Your Honor.
Okay, appreciate it.
That's number one.
Right.
Right, that was the first one I said. Plaintiff's number 11, which was, you said document 663, that was the pre-instruction on strict liability that the council wanted me to defer on because of the stipulation issue. So that one we need to circle back to. Okay? So that's what I counted as the first one.
And I had 622 as the second one, real
Hold on a
14.
second. Give me one quick. Okay, so that's the first one. We got all the way to, let's see, if you look at the December 1 letter, we got all the way to the 20, well, past the 24th, okay, yeah. 622, Real Waters, motion limiting number 14, to
Right.
preclude Rev. Chuck's testimony. The third one would be document 620, Real Waters, motion limiting to preclude any arguments relating to comparative negligence. The fourth one would be document 665, ETT's motion eliminate 4 regarding REN action, and I'm not gonna go the whole long version, we're just gonna say REN action, 665. Number 5 is document 675, ET&T's motion eliminate number 20 to pre-admit evidence regarding Nevada beverage. Number 6 is document 611, Real Waters motion eliminate number 3 regarding, including testimony regarding reference to other claims, lawsuits, settlements. 7th one for tomorrow would be Real Waters motion eliminating number 9 to preclude customer complaints, predating complaint. 8th is document 618, Real Waters motion eliminating number 10 to preclude pre-2018 customer complaints is hearsay. Then it would be document 646, ET&T's motion eliminating number 10 to exclude references to non-liver related injuries. And the 10th one would be document 653, ET&T's motion eliminating number 11 to exclude evidence of unrelated consumer complaints. Then the 11th would be document 616, Real Waters motion eliminating number 8 to limit lay testimony. Then it would be document 672, Real Waters motion eliminating to preclude lay witnesses, which would be hypothetically the 12th one for tomorrow. The 13th one for tomorrow would be document 613, ET&T's motion eliminating number 5 to exclude medical causation opinion by lay witnesses. And then the 14th one would be document 671, ET&T's motion eliminating number 14 to exclude the evidence, reference, or testimony related to alleged injury sustained by Blaine Jones. Does that work for everybody? Okay.
Yes, Your Honor,
Yes,
that's
Your
for
Honor.
Real Water.
Yes, Real Water, yes, I heard ET&T. Councilman Planners, does that work for you?
Yes, Your Honor.
Okay. So that would be Friday. Okay. And then let's go to the question asked earlier. Marcia, could you do me a favor and come forward so I can give you something? Can you hand one for Council ET&T, one for Council for Real Water, one for Councils for Plaintiffs? And I'm gonna explain what you got handed in just one quick second.
Thank you, sir.
Thank you.
Sir?
Mr. Kemp, you had asked the question earlier about voir dire questions. The court had mentioned it's standard 11. That's what this is. I'm just providing you a copy of what these standard 11, it should say in the lower right hand, revised 2/5/2018. That's usually for a smaller, straight civil case, the standard 11 questions. That's when we normally do not have a jury questionnaire. And this gets modified if parties want more questions to be asked of the jurors by the court. So what I'm going to do with this is we can discuss it tomorrow, and if you all want to touch base with each other to see if you're going to, A, want me to do any court's questions, B, do you want this modified in some sense? And tomorrow you don't have to tell me exactly how you want it modified, but I just need to know if you're going to want it modified, and then we'll come up with a date by which you need to give me modifications. Or 3, some third option that you all are requesting, okay? Does that take care of court's questions? Anything else in that regard? Mr. Kemp, I'm gonna ask you first, because you,
Thank you.
does that work for you?
Thank
Okay.
you, Your Honor.
Mr. Brewater, works for you?
Yes, Your Honor, thank you.
Okay, works for AT&T. That takes care of that. So then we go next to Mr. Odou's question with regards to the pretrial disclosures with regards to depot designations. And so what, Mr. Odou, I believe you were talking about right, NRCP 16.3, sub 2, right? Designation of those witnesses whose testimony the party expects to present by deposition, and if not taken stenographically, a transcript of the pertinent parts of the deposition and then the identical documents, which I believe is what Mr. Pepperman was saying. That gets tied to the pretrial disclosures, which is the 30-day date, which would mean tomorrow, referencing then going to the court's handout procedures for civil jury trials dated 8/17/2023, where the court exercised part of its discretion under EDCR 1.61 for complex business matters, which includes this, and tries to give some additional time for parties to figure out what meets the parties' needs best, realizing that no two cases are exactly the same and that we have to work through those different dates and times. So I'm probably going to, would it be correct to say that during the lunch hour you all did not have a chance to talk among yourselves? And so you just kind of would like some guidance from the court as to deadlines, or do you all want the opportunity to talk among yourselves and propose something to the court, and I hold off addressing this till tomorrow, which either is fine from the court? Just let me know what you'd like to do.
Joul Odou for Rowater. Mr. Pepperman and I spoke briefly and we talked about it, and just for clarification's sake, we believe that in looking at the court's order posted on the court's website and looking at the local rules and looking at the code of civil procedure, that the date for the pretrial disclosures was Monday. I heard the court just say it's tomorrow.
Mr. Pepperman initially had said it was tomorrow, then you had said Monday. That's
We
why I was
said
asking.
Monday. We had talked about it being agreed upon that it's Monday, but that plaintiff was going to start their designations now, so that if we are in court next week, we will still have time to meet and confer, resolve those designations and counter designations, and then have objections, if any, to the court before the court takes the holiday at noon on Friday of next week. And so
I'm not taking that as being the holiday time period. I just realistically gives me some time at lunch and takes a little less for me to take home for a weekend and holiday. And
Yes.
honestly, staff gets excused usually at noon or 1 p.m. So I wasn't really gonna, I was gonna ask you all if you were gonna have me have this staff stay here past the time that the rest of the courthouse is gonna be excused. If you are, I'm sure they'd be glad to stay, but I will be asking you all to do that, because from this court's perspective, if we're where we need to be, then I don't ask staff to stay, but if the counsel of the trial needs something, then I ask the attorneys what they need.
it's very generous of the court, but we are striving to completely avoid that. And so I think we have reached agreements among ourselves, but I don't want anybody to have a rough night thinking that something is due tomorrow. That's why I spoke up.
And then what you're referencing from the court's rules is what you're saying is if the parties anticipate the deposition testimony in lieu of live testimony is to be used in whole or part for more than one witness, then the parties must notify the court in writing at least 14 days prior to the calendar call, and the parties must set forth how much time is needed prior to trial to hold those objections.
Yes,
You can
sir.
appreciate that is once again in something in a smaller case, right? Not usually in the super large cases, as I gave the example with the opioid, this no way would have worked, and it actually didn't because we already had different deadlines pursuant to the case management order that was a lot sooner. So these are general subject to special masters, subject to CMOs, subject to actually the large size of the case and how much there's going to be, how much disagreement or agreement. So I think what you're saying is, are you planning on, everyone's planning on doing initial designations by Monday in accordance with 16, or you're saying you're gonna work something, so as long as the court gets everything by, like I said, 11 o'clock next Friday is I think what I said.
Yes, that's what we are striving towards, the making sure that the court has something before 11 o'clock on Friday. And we're actually hoping much earlier than that, such as Thursday. or Wednesday if possible.
So is there any outstanding questions you have about depot designations of live testimony, regardless if it is reading in or video?
No, we do not believe that there's anything due tomorrow. I just, again, if somebody disagrees, please speak up.
Somebody let me know
We're
if you
just gonna
think
file ours early, just because we're ready to do it.
it's always more helpful to do so, gives the court more time, but yes, if you all, the rules can be read that it's Monday, the court's gonna be fine with Monday.
Thank you, Your Honor.
Okay, so that meets your needs counsels for plaintiff, right?
Yes, Your Honor.
Does that meet your needs counsel for
Yes, it
real,
does.
counsels for real water? Does that meet your needs counsels for Terrible Herbst?
Yes, it does, Your Honor. Thank you.
Okay, so what we're going to do, just since I happen to have the handout in front of me, we're gonna take another minute just to make sure there's no other, no surprises for anybody. Let's walk through if there's any other questions, right? Trial briefs, EDCR 7.27, self-explanatory. If you're going to do them, you need to do them in accordance with the rules, straight 7.27 issue, right? Anybody have any questions on that? Please, the only thing I say with 7.27 briefs are, and I do appreciate wonderfully experienced counsel, I'm not saying anybody would do it, but I've heard rumors of people sometimes trying to file dispositive motions and putting them what's called 7.27 briefs. Realize if they're not 7.27 briefs, they will not be treated as 7.27 briefs, and the court can only take into account 7.27 briefs during the course of a trial. Depositions, we already worked through. Audio-visual witnesses, you've already worked through. Court recorder, I understand at least one party has requested, at least I think daily transcripts, there was some notice, and as long as you pay what you need to pay to get what you need to get, I leave that with the court recorders. Just if you do it too late, remember they're outside transcribers and they get booked up very quickly. And so if you don't put your order in, is what I'm informed, is you might be out of luck. But
I think we already ordered that for the trial.
I think that's taken care of, but that's your quick heads up there. Jury notebooks, I've not heard anybody request jury notebooks. Generally, nobody wants jury notebooks in this day and age because you put things up on screens and you get things taken care of that. Is anyone going to want a jury notebook that I need to reserve some time for?
Not plaintiff, Your Honor.
Not real water, Your Honor.
No, Your Honor.
Okay, I'm having TNT now, okay.
Yeah.
We already walked through the proposed voir dire. I think I answered all questions there. Proposed jury instructions and verdict forms, self-explanatory, straight out of the rules. Courtroom equipment, you see what you get, right? We have the large screen TVs, we have Elmos, we have the various things. Is anyone planning on bringing their own screen in? The reason why I say that is because you see the somewhat limited space with a number of attorneys, and in order to see the jury box, but once again, I didn't hear anybody saying they were planning on doing so, so we're not aware of that request. Should I be pausing for a quick second?
No, Judge, you just remind me of some other point.
Okay, is that something you need to, anything you need from me? Okay, no worries, then I'm moving on. Okay, so we've talked to courtroom equipment, jury questionnaires. You all should have gotten what you're getting it in the process consistent with the prior notifications, right? You all are, as we're getting excusals, you're getting them, and you know we're getting a lot of them, and my wonderful JA is spending a lot of time sending those to you so that you can have the nice column to get things taken care of. To the extent the actual juror questionnaires, you are got your process who's picking them up and getting them done electronically. That's all working smoothly is what I understand. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. We don't need to, you know 2.67 through 2.69, I don't need to go to that. Exhibits you walked through, you said you already made your appointment for electronic exhibits. You've already gotten your range numbers with regards to exhibits. You seem to be taken care of there. And that just generally goes over these standard issues. The only other thing that often comes up, which we don't need to necessarily discuss today, but since you have a few moments if you want to, is how many jurors you're going to want to bring into a courtroom, right? And kind of, but you might want to think that through and how you want to do that so that we can get you where you need to be for regards. We've got a little bit of time for that, but look around the courtroom. Yes, the 84 does include staff attorneys, right? So we have, sorry, I used to have a card on it that told me exactly how many seats we have back there. Well, I'll know by tomorrow because I've got a card. So you get what you get. Remember all that. This court's jury box, yes, in front. So you might just want to take a look. It doesn't have to be today, but if you want to discuss it Friday or Monday. Counting the number of juror chairs?
Yes, I have 17 here, Your Honor. 17 here and 7 up front.
8, 10, 12,
24.
16, 17, 24, which means we can at most pretty much put 25. If you think, how many do you think you're gonna need?
We did 4 alternates the last time, Your Honor.
That's it?
That's it, 4 alternates.
We didn't lose anybody.
We didn't lose anyone.
Okay, so then up to 25 seats is more than meets your needs, right?
24 is all you need, really. I mean, in terms of here, and then whatever I don't know what the count is in the back, Your Honor. But with the
We fill
exception,
every seat if you want to fill every seat. The only thing we do is if somebody requests an accommodation to have a seat between them or something like that, of course, under state and federal law, we will grant any reasonable accommodations, and we are more than glad to do so for council, witnesses, members of our public, et cetera, to ensure everybody has the best possible experience, so.
yeah, the only thing we were concerned about the last time, Your Honor, is we had clients showing up, and so we kind of placed them here. And then as things wore on and we had more space, and we put them in the gallery. So I think we should be fine if, looking at the space, 60 or so people at a time. If 20 there, maybe we'll get 80.
I can tell you tomorrow, I actually have a card that sets forth the number, it's just
That's fine.
not. It's my, well, regular nurse is not here right now, he usually has a little card that we can get out on it. It has that, and as far as your clients, we try really hard not to mix anybody in with our jurors, right? If you do need to reserve the last row for clients, then we will reserve an entire, partial row on one side. Or possibly both sides are requesting it, rather, and then that just minimizes the number of jurors we get in here, because we don't want to have an issue of people having to go in and out, right? On which seats, either in front of jurors or whatever, so we usually just do the last row to make it the most convenient for everyone and to minimize any issues. The other thing I should give you a heads up, which I think you all know, because all of you have done trials in this, with me, is that we have, when the jury actually comes in, we have those for the seated jurors, we have them actually come up the hallway and come in that door and then come into the jury box that way. We have found that that is a lot easier. It minimizes any issues for jurors having to walk by counsel tables, anybody having inadvertent papers out for jurors to see. It minimizes all those kinds of issues. And also if anybody has, if they're larger or have any other challenges, they're not having to meander through various things to get to the jury box. So we usually have, those people I'm using my hand to kind of point, is we have usually the people going into the box, and those front seats in the box go down the hallway and come in through that door. And then when we're doing voir dire, the rest of the jurors that are refilling up the gallery, the left gallery, and the right gallery, come in the double doors and then come in. So that way we minimize the amount of time for people to come in at the same time. And then during the course of the trial, we have the actual jury go up the hall and around. Just most people have found that very helpful.
So, Your Honor, we'll speak about whether or not we need 4 alternates this time. Again, all of them remain. We didn't lose a single alternate. We didn't lose a single juror, obviously. And I did the count. So you're about 49 in the back in the gallery, 24 and 25. Even if we did 46 in the back and 24 in the front, that's 70. That would be a good number, I would think.
Okay.
If we could have 70 perhaps for the first 2 days, and we can figure out whether or not we need to replace at that point.
And we'll need to walk through the rules, request or non-request on whether they're going to be striking juror by juror or doing it at the end with preemptory challenges. So we'll walk through that process, but if you have some time, I really was anticipating part of that at the beginning of next week when we had a better idea of the motion was rulings on the various motions, as well as I presume you'll be able to give me a more concrete time estimate for trial in light of where things are, so that we can just ballpark things, because I know a lot of jurors are asking that question, right?
Absolutely, no.
Okay. Anything else for the court? If not, I'm going to wish you a nice rest of your day. Is there anything else you'd like to get taken care of today? Counsels for plaintiff?
Nothing in the plaintiff, Your Honor. Thank you so much.
Nothing from low water, thank you, Your Honor.
Nothing from Terrible Herbst, Your Honor. Thank you.
Appreciate it. Thank you so much.
Have a nice
You
evening.
are, tomorrow, you're the only thing on calendar, so if you need to leave things on council's table, that you do not need it today, You are welcome to do so as long as it's not alive or dead.
And we'll be back at 9 o'clock again?
We show 9 o'clock. Does that mean you need? Seems like we're going at a good pace at 9 o'clock is going to be fine, right?
No, you're doing very well, Your Honor, very efficient.
Okay, everyone taken care of. Thank you so
Thank you
much.
so much.
Have a great one.
Really good.